I'm just sharing my screen now. Is my screen visible rightly?
Yes, your screen is visible.
Yeah. So, hi everyone. Good evening and welcome to the legal reasoning section. So, let us start now. So, let's talk about the strategy that we are here to discuss. Then we'll move on to a passage that will solve to know the nuances of the this thing. So, firstly, we'll look into the types of questions that we face. First one is the basic law passages. This can be prepared well in advance by reading basic law theories. I'll give you an example. You'll get simple questions of contracts, say that is way of acceptance, and they'll pose you questions relating to that. These theories you will generally read in books that you get. So there, these questions can be obviated. You are not very uncertain on these things. And to specially mention, four such passages were there in Clat 2021 of this nature, and I guess one or two in Clat 2020. But so this can be a strong point for you from your side, that you can prepare well in advance and you don't get surprised when you reach there. But also one caveat exists, and that is you don't know exactly how many of such questions will come. For example, you can see out of the seven, four were such in 2021, but in 2020 only two passages were such. So you can't rely on uh, the consortium that they'll give the question with to you with certainty, and that applies to everything. Basically, I guess you all know that consortium doesn't keep things on a certain in a certain way. So, but these types of questions can be prepared in advance. Now we'll go on to the next type of questions, that is legal come logical questions. These types of questions are not like those principle and application based questions. These are questions where you need to give logic to whatever legal proposition they are posing. That is, आपको यहाँ पर एक उन्होंने एक चीज बता दी कि so and so has happened, and now you have to give some reason, legally sound reason, to say that why such thing could have happened legally. So and this skill, that is why this thing happened or what could be implication of such things, was also asked in GK questions in Clat 2020. So this is some type of logical reasoning questions. So you should also be prepared for these types of questions, that they might come. They were quite frequent in 2020, and one or two passages were there in 2021 also. Now the third type of questions is random law passages. That is, you can't prepare for them in advance very well. So, but you can, take the law view in large and approach them slowly. As I have written, that it can be prepared by reading different blogs on various laws in general. That is, you don't need to dig deep into every law, but select some basic topics that revolve around and read them, just to have a glimpse of them, to have essence of them in your mind, that you don't find yourself off guard that I have never read of such law ever. So you must be well versed with all these things. Also, when you read all these articles, blogs, and I would recommend when you read newspapers, especially the Hindu and Indian Express, you will find on the second page, most of you might be reading Delhi edition or whatever edition, the observation of high courts and supreme courts. Let it be the smallest of cases, maybe bail, petty theft, whatsoever it may be. Read it. It gives you grasp of law. It gives you appreciation of law. It makes you understand some basic concepts. It might pose you with a word that you might have not encountered ever before. So you can learn that. So it will help you much, reading and all that. So, and yeah, one thing that some aspirants go the wrong way is that they go much in too much of reading, too much of wrong reading, I would rather say. Like they read companies law, maritime law, they read whole judgments. You don't need to do that kind of thing. Law school provides you enough of that, so you don't have to worry now. But read basic laws, like I'll say constitutional law, torts law, human rights law. These kinds of laws have been prevalent in Clat examination from time. So just have a big scope, but don't go too wide. Like maritime law and companies law, they never come such laws. So be prepared for that. So, and yes, and one more thing I'd like to add, that do not forget the OLETs. See, what's important here is you getting into good law school. I am myself studying in GNLU. It's a really good institution. But one guy that studies maybe in Gujarat, that government law college Mumbai, isn't that bad. It is really good to go there too. So you can't just be focusing on Clat examination. Because it's all on the what happens on the last day. So you can't bet all your uh, money on one stock. You need to diverge it properly so that your stakes are secure and you don't just get ousted from the race if you just lose Clat. So prepare for LETs also, OLETs also. And regarding to the legal reasoning in OLETs, the principle based questions that mostly come in OLETs, I guess everyone except for Clat asks the same types of question. That is, principle is given, facts are given, and you have to decide according to that. So those types of questions make you understand the law. And in some other way, I would say, and I have written that too, that those small questions are some or the other way the bigger questions that you face in Clat. It's just that they are bigger passages, but question is being made. One question is being made on one line. So you need to focus on these questions also, and do not take them for granted that I don't want to do OLETs. Maybe you don't want to do it. I take it, but still those questions are really helpful if you want to have the edge in legal reasoning. Yeah. So now we'll jump onto this passage that we are to do. So I'll give you a total time of 5 to 6 minutes, I see, and then we'll go on to the question. But yeah, let us do one thing, that we'll first see the questions quickly. Okay, I'll read them slowly, and I'll suppose that you'll all read it in the same time. Moving on. Yes. Now I'll go on to the passage, and you'll have 5 minutes to read it. So it's 2 pages. After 3 minutes, I'll change the page. All right. Uh, this passage is not for testing your speed, but rather just to make you understand. So read it slowly and take your time. I won't move it for another 2 minutes or so.
Once you're done reading the passage, just write it in the chat box that you are done. Then he will be moving to the next page.
20 seconds more. Read it. So moving on. Thirty seconds more. If you have read it, type done. Yes. Is everyone done with this? Reading this?
Yes, you can continue right now.
Yeah. Oh. So I'll read it once again for everyone's convenience. In a bid to protect the identities of those involved in POSH, that is prevention of sexual harassment trials, the Bombay High Court, in a recent judgment, has set out guidelines that appear to be prohibitive and may become a dangerous precedent for all lower courts in the states of Goa and Maharashtra. So, firstly, it's talking about jurisdiction here. So, you might not understand it, but just understand that it is a dangerous precedent for all lower courts in states of Gujarat, Goa, and Maharashtra. So, its scope is limited to Goa and Maharashtra and could be relied upon by other courts in the country and could be relied upon. It's not binding, it can be relied, it can be used to support. The guidelines laid down by Justice so and so on so and so prohibit the disclosure of identities of the victim, accused, and witnesses and mandate that all such court hearings be held in camera or in judges' chambers with only the court steno, plaintiff, defendant, and their lawyers being present. Even court orders and judgments will not be delivered in open court. Parties to post trials are prohibited from disclosing any information relating to such trials, including the final order or judgment, to the media or publicizing the same via social media without securing permission from the court. Breach of these conditions will be contempt of court. It's doing so and so will be contempt of court. Underline such things. Judgment in posh cases will no longer be published or uploaded for public consumption without permission of the court. And even then, yeah, one more thing. Mark these words even or uh, except. Such are extreme words or the words that may turn things out of your way or in your favor. So, especially pay attention when such words appear. Even then, publication of only a fully anonymized version can be allowed. For any lawyer to access this judgment, a court order will have to be obtained. The Sexual Harassment of Women at Workplace, so and so Act 2013, POSH, mandates that government and private organizations redress complaints of sexual harassment at workplace in a manner that is simpler and quicker than judicial process. The need for confidentiality in these guidelines has also been stretched far more than necessary. Identities of victims, survivors of child sexual abuse, and rape are required to be kept confidential from the media unless they, yeah, again this one, unless they exercise their rights under Section 228A, Clause 2, Subclause B of the IPC. This is done to prevent victims from being ostracized by the society. If this same privilege is extended to complainants and witnesses in the POSH case, that would be beneficial because there is reasonable expectation of retaliation at the workplace. It is for this reason that Section 16 of the POSH Act prohibits members of the internal committee and employers from revealing identities of those involved in POSH inquiries. However, unlike the blanket ban imposed by these guidelines, the POSH Act does not expressly prohibit complainants and respondents from themselves revealing this information. So, the however gives mostly time an exception. So, an exception has been given that, however, if the complainants want themselves to reveal their identity, they may do so. Moreover, the POSH Act allows the publication of the justice secured to victims, which must also be revealed by every organization in their annual report without identifying the parties in order to let the public, uh, in order to let the public, so I can't read it, action taken by employers against those who indulge in sexual harassment. I will go on to the questions. Question number one, you have 30 seconds or so, and if you are done, type the answer and we'll move forward then.
And if you guys wish to see the passage once more, you can ask him to move the slides.
Yeah, sure. You can tell me. I'll do that. You can unmute yourself and okay.
Okay, Rishi, you can move the slide. They are asking you to move the slide.
Sure. I guess this one, this
The
slide
first,
or the
no,
first one?
first slide
First one?
first. Yeah.
Yeah. Should I get back to the question?
Yeah, Rishi.
Yeah, I can see everyone saying, someone said option A. Any more answers? Yeah, I guess we should move forward. So I saw that one answer has been given as A, but let's read the question. A girl, namely X, works in a factory in Nagpur, a city in Maharashtra. So what I said about the thing about jurisdiction. So Nagpur is in Maharashtra. It has been explicitly stated. So we'll take that the guidelines are binding on a court in Nagpur. She is sexually harassed by one of her senior colleagues and she files a complaint for the same. All the pre-trial procedure is completed and the trial is about to begin. Whose discretion is it to decide that whether the trial should be held in open court or in judge's chamber? So the answer will be D. Uh, it's because let's start by eliminating. So we'll go first with C. The respondent, B, the claimant. No, these answers, these options have not been mentioned. So the doubt is between A and D. So we'll cut A because guidelines have been given. Judge has to follow them. He does not have to decide whether he would do it or not. The guidelines have been given. They have been laid down by some high court judge, and now the trial level courts have to follow it. It's not. It has not written anywhere that it's on the discretion of the judge sitting on the trial or for the trial that he has the discretion. So this was a confusing question, as most cases what happens is that the judge who's sitting decides what the course of the trial will be. But this was an exception, as was stated. So one more advice: that stick to the passage. Whatsoever is stated, stick to it. Your prior knowledge sure does help, but you don't use it so much and like this when you are solving passage. Moving on to the next question. So I am getting answers. I got three answers, C, C, C. Yeah, so we'll read the question first. The trial is concluded in the above mentioned. If anybody is left, they can raise their hand or just type a message. Okay, so we'll move forward anyway. The trial is concluded in the above mentioned case, and the judge pronounces his judgment as not guilty. X, the girl who was harassed, deeply displeased by the judgment, writes a blog post criticizing the judgment that has left the defendant free and demands justice from the people. Many people believe her and start protesting against the judgment of the court. What is X liable for? So we got the right answers. C, that is contempt of court. I had highlighted that point prior. Yeah, so we'll move on to the next question. Guys, do a little quick. I have one more thing to tell you after solving this question. Sir, guys, this one is easy. Again, the same principle follows that I had earlier told.
Yeah, Rishi, you can continue. They've answered it.
Yeah, sure. So, okay, I couldn't see. See, we'll read the question. A district court of Alwar city of Rajasthan published the anonymized version of the judgments relating to Posh Act without any court order, even after coming of these guidelines. Was the court correct in its conduct? Choose a answer with correct reason. So, answer is D, as you can see, but we'll anyway eliminate other one. We'll go first with A. No, because the court in question has to mandatorily follow the guidelines laid by Bombay High Court. See again the question of jurisdiction. So mandatorily it does not fall anywhere. It is persuasive. So they don't have to mandatorily follow it. So B, yes, because the court in question is a unique exception to the guidelines. No, it isn't. No such thing has been mentioned. Uh, it is an exception, but it's not unique. It's not one. All other courts outside Maharashtra and Goa are exempted. And C, no, because the court in question hasn't taken the victim's permission. No, this is irrelevant again. So we'll go with D. Yeah, guys. So we have two more questions left, but because of crunch of time, I'll move forward to one more thing that I had to tell you guys, and I'll get this question forwarded to you, the ones which are left. So another important point: read and read more. One thing that I have experienced and felt throughout my preparation was that guys and people who had reading practice and reading habit from an early age were were at an advantage while giving Clat, and they could give it just like that. The people of metro cities or whatsoever, maybe they were from small city, but if they had a habit of reading, they had an edge over us. So I would suggest that you read and read a lot, and this might include various things. I have listed him all of these here, like blogs, articles, basic vocab, not only of English but legal vocab. For example, I just stated the word jurisdiction. Someone of you might have known the word jurisdiction, but someone of you might have not. So, and the examiner presupposes that you know these words. So you can't help it. They won't define every each other word. So you have to prepare yourself from for that. And one more thing that newspaper articles, as I said earlier, that you will have to read them, and don't fret seeing those long articles and things like that. You are to become lawyers, judges, whatsoever. You are to come into legal profession, and you have to read much and much, 100 pages, 1,000 pages. You have to read like stuff like this. So you should think of it this way, that this is a small thing that you are doing right now, very petty thing that you are doing right now. You have mountains to climb and you are climbing a small hill in a village. So you should go with that mindset, that oh, reading a newspaper, it's habit. Reading two blogs, reading one article, doing basic vocab. And yeah, I have added one special thing: class 12th legal studies book. I had opted for legal studies in my 12th standard, and I would say that it really helped me, not only because it gives you basic understanding of various law, but also it it goes beyond some of the basic laws like tort contract. It goes to administrative law, constitutional law, transfer of property. So it gives you good grasp of law in those fields. So I would suggest you do that, and read a lot. And I would say that don't read easy things like what you like to do. Like I would say that some guys like reading novels. So just don't go over and over read novels. Read something that feels tough, like reading editorials, like reading uh, difficult blogs, like the writing in the legal writing, as you might have noticed in the course of your preparation, is quite different from the normal English that you guys all read. So you must prepare for that. But because once you're accustomed to reading all such types of things, so yeah, 1 minute. I'll answer all of your questions. You can type it, but first listen to me. So you can what was I saying? That no, you don't have to require 11th legal studies book. You can
Rishi,
read it, but
actually,
it's not that important. Huh.
what you can do is you can reply them in the chat box
Deal
after
with
your
these
part.
questions in the chat box. Yes.
Sure. I'll do that. Okay.
Okay, Rishi, thank you so much for your time.
Yeah.
We were delighted at Lightning Dreams to have you